How about we take a peek at Ripple's complaint against the SEC? An essential first step is to get ready for the April and May deadlines. Judicial Magistrate Sarah Netburn issued a new scheduling order while the trial between Ripple Labs and the U.S. Securities and Exchange Commission was underway. The United States of America was the site of the trial. Subject of the order was Ripple's request to the SEC to withhold records and materials intended for use in conducting a brief regarding remedies. The request was submitted by the SEC. The Securities and Exchange Commission's SEC brief presentation outlining Ripple's role in the remedies section is a crucial portion of the case. During the meeting when the parties proposed the revised scheduling order, many topics were covered. Among these, Ripple's decision to withdraw its expert papers from the SEC was discussed. This happening demonstrated that everyone involved was eager to resolve the issue. The deadline for the Securities and Exchange Commission (SEC) to respond to Ripple's request is April 29, 2024, according to Magistrate Netburn. This follows the directive from a previous order provided by James K., who was once employed by Twitter. 3 business days after the original date originally scheduled in the order, on May 2, 2024, will the Securities and Exchange Commission (SEC) be required to issue a response. The reason behind this is that Ripple is expected to respond on January 26, 2024. The scenario around Ripple is becoming increasingly worrisome, according to reports from numerous specialists. The intricate series of events that unfolded in both the SEC and Ripple cases were illuminated when the judge issued orders to schedule hearings. In his view, the expert's investigation raised some valid points, and it was difficult for Ripple to provide analytical solutions to those points. This was because the report's introduction muddled the connection between the title and the content it really covered. Andre Fox's professional judgment on the XRP issue is unquestionable, even though the court may give the rule-to-rule foundation argument a lot of weight after hearing it. The amount of money available will decrease proportionally if the Securities and Exchange Commission (SEC) reduces the penalty. Also, Smith will have a harder time holding free and fair elections after Sarah Netburn is nominated to be a federal judge in the U.S. District Court for the Southern District of New York City, thanks to the publicity campaign going on right now. This is due to the fact that Sarah Netburn's nomination is also triggering the PR campaign. Crypto sector insiders are showing their admiration for Netburn's careful handling of legal matters. The announcement that Netburn had been appointed as a federal judge was met with dissatisfaction from many communities, the most vocal of them being Bitcoin enthusiasts. A great deal of animosity was directed at this resistance. Coinbase General Counsel member Paul Grall was the one that backed Netburn and praised their work on the XRP case. Using the phrase "a seminar and an instruction book for the entire industry" himself, he characterized the gathering. To be more precise, she was able to win over the XRP community largely because to her criticism of the SEC's implementation of the rule. Even though she had previously criticized the SEC, she managed to win everyone over because of it. One of the most important things that Liz has mentioned in this deal is the rules she has made for when William Hyman's amazing 2018 Ripple lecture on cryptocurrencies is shared. The planned year for Hyman's talk is 2018. This shows how committed she is to making sure everything is delivered in an open and fair way, because she has done this. Not long from now, Net is expected to receive a nomination to the role of federal judge. As part of his responsibilities, he will try to make a big splash on matters pertaining to opening up new markets and making legislation easier to understand. He was formerly known for his work as a prominent attorney in the Bitcoin industry. He had been in this role not long before. This case is being handled from a different angle. The trial phase of the legal battle between Ripple and the U.S. Securities and Exchange Commission began last week, the commencement of the trial phase. Numerous individuals involved in the field anticipate that the test will yield positive results. Magistrate James K. Phelan, an American attorney, has disclosed fresh details regarding the scheduling order. The information was supplied by him. The two most important parts of this case, according to Judge Sarah Netburn's opinion, are the request for remedies and the publishing of the ultimate verdict. There are 3 business days after the government agency's deadline of April 29th for responding to the request from the government agency for Ripple to respond. The appointment of Netburn as district judge for the Southern District of New York's Judicial Court was announced not long ago. This is the most recent event that has happened in relation to the situation. You should know that her past behavior has demonstrated that she has a cautiously positive opinion about Ripple's native coin. You need to pay close attention to this. Now, the XRP army may rest certain that the company has a fighting chance at a significant legal victory in the near future. In my opinion, XRP has more than just monetary value, it also has practical applications that set it apart from other cryptocurrencies like Bitcoin and Ethereum, as the court noted in 2021 and the council confirmed. Something like this has finally clicked for me. Jeremy Hogan has something to say regarding the blockchain technology and the various possible and plausible outcomes. According to Hogan's latest statement, the lawsuit is expected to be resolved by the summer's end, and a settlement of $100 million is among the likely results. It was because Hogan made the comment that this belief was formed. As far as I can tell, the court is going to fine Ripple $100 million, but he's going to spare the SEC some trouble by saying that the company is exempt from paying any fines. In my opinion, that is correct. The business was previously threatened with a $2 billion fine by the Securities and Exchange Commission (SEC) for violating many rules pertaining to the selling of XRP. Because the company had broken so many rules, something had to happen. Ripple has always maintained its stance that its cryptocurrency is not a security and so should not be governed by any central authority. Stuart Alderati, the company's chief legal officer, presented numerous compelling arguments in favor of the notion that the fine should not exceed $10 million. The Ripple Labs-affiliated coin XRP has been the subject of a great deal of recent activity. Not long ago did this take place. Traders known as whales traded a staggering number of coins, totaling 180 million bitcoins. In the cryptocurrency community, this incident has made headlines, especially in light of Ripple's continuing legal battle with the Securities and Exchange Commission. The coincidence of these whale trades, which took place simultaneously, is what has garnered all this interest. The potential consequences for the market continue to cause concern, despite signals that XRP's price is showing signs of improvement. Because of this, the Bitcoin market became noticeably more popular. In contrast, attention soon turned to the conduct of very large holders, or whales, who had made a string of gigantic transactions involving over 180 million XRP. The transfer of 100 million XRP between two anonymous wallets is another significant transaction that has further eroded people's faith in cryptocurrency. Many are now even less confident in cryptocurrency as a result of this transaction. This page is not intended to provide trading advice, and we are not liable for any losses that may occur as a result of investments based on the information provided. Do your own homework and consult an expert in the area you're interested in before making any investment decisions.